Okay, substantiation. We touched upon this a little earlier. What I want to say here is really, I mean, everyone knows that you must have a reasonable basis. You cannot put out facts that seem to be based on scientific evidence. You can't put that out there without it being true and backed. Not only does it have to be true, but it has to actually be backed by scientific evidence before you disseminate the ad. And the interesting thing about substantiation is, even if it is true, but you didn't have the substantiation ahead of time, that's still viewed by the law as false advertising. So you must have your scientific studies done ahead of time, and they must be legitimate. There's a great case of everybody remembers, who knows what viscosity breakdown is? Remember the motor oils? This was Pennzoil versus Castrol. And in that case, the substantiation issue, it was an issue of not having substantiation. Pennzoil in that case had done a massive amount of studying about viscosity breakdown, but the court found that the standards that were used in the substantiation were not consistent across the industry. So for Pennzoil to make the claim that its product was a superior protector against motor wear was not substantiated. Even though they had substantiation, they didn't have proper substantiation. Their substantiation itself was misleading because it wasn't in accordance with the way the industry viewed the name viscosity breakdown, or the word viscosity breakdown. So this is a, you can't win for losing. I mean, it's a difficult situation, but it's got to be reasonable and in accordance with industry standards.
What about stale research? Like if they're using research that's 10 years old and technology's changed, but they're still quoting, an old research.
No.
You can't do that?
You cannot do that. Yeah, no, I mean, that's the kind of thing that the key word here is reasonable basis. And that's the key word that they quote all the time in the cases about substantiation. And this is a big NAD, a big FTC issue, and AGs are looking at this too. Competitors are looking at it too, but the competitor in those cases has the burden of proving it's not true, and the others, you have to prove it. And so if you're using old evidence, that's the first thing. Especially, I mean, old evidence is not per se bad, but if it's old evidence that really has been superseded by new scientific theory, then you're out of luck. Now, that's not going to constitute substantiation.
Are there independent consumer protection organizations that kind of perform
monitor? Yeah, there are. And not only are there independent consumer watchdog organizations, but it's important to keep in mind that every industry has its own set of standards and watchdog organizations too. So, and I mean, standards and its own independent agencies in some cases, like pharma has the FDA, food has the FDA, alcohol has the Bureau of Alcohol, Tobacco, and Firearms. Those organizations have their own set of standards that supersede and supplement the laws of the regular false advertising laws that apply. So yeah, that's a good point. Yeah.
Disclaimers, and maybe I don't want to go too much of a tangent on you, but consumers don't read the disclaimers.
Right.
They're in mouse type, they're reverse out, and until HD TV came along, you couldn't read them unless you read up on the screen. Seriously, I've seen, a friend of mine was involved as an expert witness in one of those cases between a couple of paper towel companies.
Oh yeah? What was how was he involved?
So I don't remember how it was resolved. It was some claim about the ability of the towel to pick up, and I think it was between the two big paper towel companies.
Yep. That was a 2003 case.
Yeah.
He was involved in that?
Yeah. We got into this whole thing, I talked with him about it, we got into this whole thing about who reads disclaimers. Mm-hmm. And he wanted to know if I had seen any research about who people read disclaimers, and I could not find any. I mean, I went through all sorts of databases. So does the FTC must know this, that nobody reads the disclaimers anyway?
Well, like I said, there's an FTC guidance. There's some guidance on what the content and typeface, size, speed of reading, all those issues are very well developed in the law, and the FTC has very fine-tuned requirements about disclaimers. So, I mean, I think you're right. I think there's a general consensus that people don't read them, but at a certain level, you're on constructive notice. You as a consumer have constructive notice of something if it's disclaimed. Yeah, and if it's disclaimed in a conspicuous enough manner, then you've provided reasonable notice. That PG case was a great one. Yeah, that was the case there was, it wasn't about the quilts, but you guys may remember this case where Bounty and Brawny. So Bounty, they wipe up the spill, and then Brawny, they wipe up the spill, and the water continues to drip off of the Brawny towel. Whoops. Did I do that? I think I did.
No. It's a cease and resist.
There we go.
Should have clicked yes?
We blame Gary anytime.
That was another case where a heavy-duty, super, heavyweights dueling it out, fighting over something that was. I mean, I guess the paper towel market is very. Those are the two market leaders. They have 45% and 40% respectively for Brawny and Bounty, and the smallest differences lead to noticeable and measurable losses of millions of dollars and gains of millions of dollars. And that commercial, the Brawny folks at Georgia Pacific were saying the angle of the hand that was wiping up the Brawny on the Brawny example was a slightly different angle of the hand than the Bounty example, and therefore it caused, they use these technical terms and I don't remember what they are, but it caused the towel to not, the liquid didn't soak into the towel enough. It went over the surface of the, and it was a viscosity breakdown, right? Something like that. So, okay. So we'll move on to, let's see, now we will move on to puffery. Okay. So puffery, this is, everyone knows what puffery is, right? That's sales talk, best, most exciting, world famous, those kinds of things. There's a fine line between, so here's the definition of puffery, but the key, there's a fine line between puffery and false advertising. A lot of people can recognize the terms. Here are some terms that, let's see where my page is on this. The terms that have been viewed as puffing are perfect, these are all in legal cases, perfect, prime, exceptional, a bargain, original, comparable in quality, that one's questionable to me, and wonderful. So all of those are typically viewed as puffing terms. However, you can bring a term that would ordinarily be puffing and make it into something that's not puffing. In this case, this Papa John's case, everybody who knows the logo, the tagline of Papa John's, who can recite it? Better ingredients, better pizza. Okay, so the court in Pizza Hut challenged Papa John's on that tagline and said, that's not true. The court, and this is an interesting illustration of crossing the line, because the court said ordinarily, better ingredients, better pizza, no problem. That's puffery. That's the definition of puffery right there. However, in this particular case, what Papa John's had done is started to compare the actual ingredients and say, we get our tomatoes from here, we get our bread and the ingredients for our dough here, and so forth. And so the court, in essence, said what Papa John's has done has taken an otherwise puffing type tagline and turned it into a qualitative, measurable, factual message. And so Pizza Hut ended up winning that case, so that Papa John's was no longer, they're still using the tagline, but they're no longer able to provide those same comparative statistics in that way. So, and there are other examples of, I wanted to give you the other list of cases that I found where things that were found to be not puffing. The Pennzoil case, protects better was the key there about the viscosity breakdown, and Pennzoil took the position that was just puffery, and the court said, not only is it not puffery, but you were the one that tried to substantiate it through your own faulty testing, and so that's not puffery. Works better for a pain reliever. Again, that was viewed as being sufficiently verifiable enough to be not puffery. 5 times better for a carpet cleaner. I'm wondering how they came up with that one, but that one was deemed to be not puffing. And then finally, this was an interesting one. Best waterproof fabric you can find for outerwear. Now you look at that one, best waterproof fabric you could find. If it said best fabric you can find, probably puffing. But when you say best waterproof fabric you can find, the distinction is that they're now saying that this is the most water resistant or waterproof fabric that's out there, and that was deemed to be verifiable and false.